We are here on behalf of instructions that our law firm received from one Frederick Bukeri, who duly instructed us to file a petition to the Judicial Service Commission for the removal of a judge of the High Court, namely His Honorable Justice Anthony Mrima. This petition to the JSC was premised on the judgment that was delivered on the 23rd day of May 2021 by virtue of file E25 of 2021, where the judge pronounced himself and made a finding that the police and any other investigative agency mandated by law cannot draft, sign, or present charge sheets before court of law. This judgment then gave the prosecutors of this country, namely the Office of the Director of Public Prosecution, the mandate to now present, draft, and sign charge sheets before criminal courts of law. What is important to note is that in the entire pleadings of this case, the Office of the Director of Public Prosecution never asked for these orders. These orders were given to a party that was never asking for these orders. And it was clearly evident because what followed thereafter was confusion in all the criminal courts of law. The DPP, who was now then mandated by virtue of this judgment to draft and present charge sheets before court of law, has since presented a number of at least 5 different charge sheets that in the very essence have never been gazetted by any court of law, charge sheets that in essence do not have any legal bearing except that which comes from the pronounced judgment of Justice Anthony Mrima. Now, our petitioner, Frederick Bukeri, is of the opinion that this confusion on drafting of charge sheets has resulted in issues of national security. That national security is now a threat, especially at this time when we are nearing the general elections of our country. The police are now confused, have been confused since that judgment, because what the issues that we have raised, for instance, in that petition, is the issues surrounding rights of an arrested person. What are the issues that surround rights of an arrested person? It was the averment of our petitioner, Mr. Frederick Bukeri, that the judge, the honorable judge, failed to consider in its entirety the effects of this judgment in practice. Because once an arrested person is arrested, he has the right to be informed of the reason of the arrest. This information is that which has been drafted already. So once a police officer arrests you and does not inform you promptly of your reason for arrest, because they have to wait for the Director of Public Prosecution to prefer charges, that is already a breach of fundamental rights and freedoms. Another important right of an arrested person that was never taken into consideration when this judgment was pronounced is the right that you ought to be produced before a court of competent jurisdiction within 24 hours. Now, if you have been arrested and you're still waiting for the Director of Public Prosecutions to decide whether or not to prefer charges on you, and the same prosecutors have to be in court the whole day to prosecute matters, this right is highly likely to be breached. It's highly likely to be unobserved in its entirety. So our petitioner, Mr. Frederick Bukeri, is questioning on the competence of Honorable Justice Mrima on the grounds that his judgment pronounced has caused national insecurity. The criminal courts of law are no longer functioning. That week that the judgment was pronounced, the week of the 23rd of May, we saw many plea takings being deferred. Being primarily an advocate of the High Court of Kenya practicing in the criminal sector, there were very many issues that we raised, preliminary issues that we raised challenging these charge sheets because they were not something that we had recognized in law. And this, in effect, delayed justice, and it delayed arrested persons or accused persons going through the due process of law as is required, which in essence should be expedient, because justice delayed is justice denied. I will leave it to my senior to now update us on the latest happenings, because this judgment was up there. There was an appeal preferred from this judgment, and Mr. Danson Omari is going to expound on that.
Before my lines here comes in, the pronouncement by the Court of Appeal regarding the appeal and stay application presented before it goes a long way to vindicate our client, Mr. Bukeri, on the competency of the judicial officer who issued those orders without giving consideration of the practicability, and such that the finding and the directions that it is the DPP to draft and present charge sheets in court was an order issued in vain. Therefore, we applaud the Court of Appeal and we look forward to normalcy, getting creeping back from the confusion that suspects have had to undergo as they were being processed before being presented before court. That's it.
As many of you are aware, there was a petition that was filed before the Constitutional and Human Rights Division for Justice Mrima in the famous case of Humphrey Kariuki, and the judge made very drastic findings. One, declaring that the police charge sheet is an illegality, and therefore the manner in which the charge sheet must be drafted, it will only be drafted by the DPP, it must be presented by the DPP, and therefore that decision was read on a Friday and it took effect on Monday. We did file a petition challenging the implementation of that judgment, whereby the DPP, because of lack of capacity and either unpreparedness and following the procedures, utilized more than 5 to 6 types of charge sheets. The matter is still pending before the court because the charge sheet that we challenged, the DPP, is not the charge sheet that was presented before Justice Mrima. Aggrieved by the decision of Justice Mrima, the Attorney General of this country, the Inspector General of Police of this country, the Director of Criminal Investigations of this country, the Director General of Kenya Revenue Authority, and all other agencies that had been barred by the judge not to prefer charges, moved to the Court of Appeal to challenge the decision of Justice Mrima on the ground that that decision has brought a total collapse on the criminal justice system of this country, where rapists, defilers, murderers, gun people who have been found with a huge cage of guns cannot be charged because the procedures, the DPP cannot. Today, the Court of Appeal sitting in Nairobi, presided over by the President of the Court of Appeal, Justice Musinga, Justice Murgor, and Justice Fatuma Sichale, has stayed the decision and the judgment of Justice Mrima, and returning in effect the judgment of the Court of Appeal now returns the situation in the criminal justice system as the law provides, as it was before Justice Mrima's decision that caused chaos. So as it is now, the police, in form of the Director of Criminal Investigation, the National Police Service, the Director of the DG for KRA, KWS, and all entities that were charging people, were drafting charges, now have the leeway to draft the charges, present them to court as it was. This, in essence, completely throws out the decision to charge, which was anchored on this judgment that it is the DPP who has the power to charge. And therefore, now we are likely to see normalcy in the criminal justice system, where the police will implement Section 137 of the Criminal Procedure Code that gives the police the infrastructure, the mechanisms on how to draft a charge sheet. Section 89 that was left intact now is in place, that it is the magistrate who has the jurisdiction and the power to admit a charge sheet. And the Director of Criminal Prosecution will remain to prosecute matters as they appear in court. In essence, any document purported to emanate from the Director of Public Prosecution as a charge sheet, as we speak today, is a total illegality. Remember, quite a monumental task. It has taken us quite a lot of time to fight for the rule of law to proceed and to prevail, and the court has given those directions. The Court of Appeal has restored order in a criminal justice system that was disrupted. Remember, when we raised this question, the DPP in his bulletin said that he never asked for those orders. So the judge gave orders that were never prayed for. Aggrieved by that revelation that the judge was never given a matter to decide, we were instructed to move to the Judicial Service Commission for the removal of the judge on grounds of incompetence. And we are provided the grounds of incompetence being that if the judge listened to the submissions of the Inspector General of Police, the Director of Criminal Investigation, he could have not thrown the country in such a quagmire where there's no certainty, there is a breakdown 100% of the criminal justice system. We have filed a petition for the removal of the judge. Remember, there are other grounds that the judge's judgment has caused. For example, you remember the other day, he stopped the recruitment of judges of the Court of Appeal and the High Court. The Court of Appeal stayed that judgment and allowed recruitment to proceed. Remember, and there are very many others that the Court of Appeal has rushed in to stop anarchy being occasioned by judgments that have not been properly evaluated, the impact they have to the country. The impact they have is tremendous, and therefore that is the reason we have moved to the JSC for the removal of the judge on grounds of incompetence based on the decision he made. Therefore, lastly, we appreciate the Court of Appeal for being there as the only prefect to help the country not go to the dogs as it had gone to the dogs. So as practitioners in the criminal law, we know by effective today, by tomorrow, only the police charge sheet will be caught. Only the police charge sheet shall be signed by the police officers, and that is the law. The question that is there is that now that the